Honor, can you see that? It's a little white on my screen.
It's a little white on ours too.
Pretty clear.
No.
Face the other way.
That's all right.
Yeah, there it is.
Yeah. Okay.
Chief Justice Melton, Presiding Justice Namias, may it please the court. My name is Devin Rafis, and I, along with Manny Aurora, represent the appellant in today's matter, Dundell Cash. Now, there is a strong possibility that an innocent man is sitting in prison today because he received an unfair trial due to the state's lengthy, negligent delay. And we're here today because the trial court incorrectly weighed the Barker factors in its order denying appellant's motion for new trial. Now, generally, a lower court's findings are reviewed for abuse of discretion, but that deference owed is diminished when the lower court's findings are clearly erroneous, unsupported by the record, or if the trial court misstates or misapplies the law. And that's what happened here. First, the lower court incorrectly stated that the length of delay should not be weighed heavily against the state, and we submit that it should. The Supreme Court precedent and this court in State v. Porter said that the correct way to calculate the length of delay is from the point of arrest or indictment, whichever is first, to the point of trial if a trial has taken place. And here, our calculation based upon the outline that I've provided the court would be 29 months. 6 months from the point of arrest to the no bill, and then another 23 months from the point of the true bill to the trial taking place. But the Barker factors are flexible, and the Supreme Court has held that they have no talismanic qualities, and in fact, they should be considered with other circumstances that may be relevant. And the Second Circuit and the 11th Circuit have held that pre-indictment delay is relevant to the speedy trial analysis.
Have we ever held that?
Your Honor, this court has not. But the 11th Circuit and United States v. Ingram has held that although the pre-indictment delay should not be calculated into the length, it is appropriate and should be considered when determining how heavily we should weigh the post-indictment delay against the state.
So how does that work? So my understanding of the 11th Circuit case law in particular is that the rule they've laid out is that you don't look at pre-indictment delay until you get, with post-indictment delay, above the presumptively prejudicial amount that triggers the Barker analysis. Then once you start doing the Barker analysis, pre-indictment delay may be relevant to consider how heavily to weigh the post-indictment delay against the state. But it doesn't change the length of the post-indictment delay. What does that mean?
Your Honor is correct.
Because there's only like 2 cases from the 11th Circuit that have even done that, and only one of them have actually gone in favor of the defendant.
That's correct, because these cases in particular are very rare with these particular circumstances that we'll get to in a moment. But Your Honor is correct in saying that the calculation should not consider pre-indictment delay. But it is appropriate, as I mentioned, especially when considering inordinate pre-indictment delay, to factor that in when considering how heavily to weigh it against the state. So in United States v. Olivia, the 11th Circuit again, while in that case they said that there was no inordinate delay, that case in particular, there was multiple bank robberies, there was multiple co-defendants, there was a complex conspiracy charge, there were over 100 exhibits at trial. But our case is substantially different. We have one defendant, we have one shooting, we have one murder charge, no conspiracy charge, and the investigation was complete within days. I mean, they had probable cause to arrest the night of.
So the U.S. Supreme Court has said that they're sort of the policy interests that this speedy trial right serve are sort of twofold, right? There's the interest in not having someone languish in jail indefinitely without a resolution of the case. And then there's the issue of prejudice to the ability to actually defend yourself. A pre-indictment delay where someone is not in jail doesn't raise the first issue. And the prejudice inquiry is a separate prong of Barker. And the judge here didn't find any actual prejudice. So what is it that the pre-indictment delay actually did in this case?
Well, Your Honor, that leads me into the reason for the delay and the prejudice prong. And the whole reason the delay was caused is because the state was searching allegedly for the sole eyewitness. And I have an exhibit here I'll just put up for just a moment, where you'll see that the detective, after Dundell Cash was arrested, went back to interview some of the witnesses again. And one of the witnesses said that the sole eyewitness, Dennis Archer, was killed. The state, in trying to confirm that, did run a Lexus search, called the probation office, and did a few other minor things like sending a letter to a last known address, which essentially said, you're a witness in a criminal trial, please call us. But after January 2009, the only thing the DA's office did was run a criminal history search once a year. And that's it. There was no police involved. There was no detectives involved. This was someone inside the DA's office that would just run a computer search once a year. And Your Honor was right in pointing out that the benefit of a speedy trial right is not only for a defendant, but it's also for society and also for the victim. And it's bad for the victim's family because there was no investigation to prosecute their son's murder.
So you're arguing diligence. I thought the question was more about prejudice.
And the prejudice comes from, because of that delay in searching for Mr. Archer, the missing witness, we have a critical defense witness with potential exculpatory information that had died. And that defense witness would have said that he picked up Dundell Cash the night of this shooting from the club, and because he picked him up, he would have seen what clothing.
But now you're arguing beyond the findings that the judge made, right? The judge didn't find any actual prejudice from the delay, did he?
No, the judge did not find the prejudice prong did not weigh in favor of the defendant. But the prejudice is there, Your Honor, because we have a missing witness. This court and the Supreme Court has held.
The potential exculpatory information, what is your position on what that information is?
Your Honor, we have a critical defense witness that would have shown that that Dundell Cash was wearing a black jacket with blue jeans when he picked him up the night of the shooting.
But it seems like there's sort of multiple versions of the clothing in the record, and they all are kind of on this spectrum of color that's roughly around a dark color. Is that right?
Yes, Your Honor. The majority of the witnesses state that it was a grayish colored hoodie or sweatshirt. And that's different from a jacket without a hood that's black.
But you said a majority of the witnesses. What do the other ones say?
There's a few that say a blue colored sweatshirt or hoodie, but almost all of them say that it was grayish in color. And that's why this defense witness is so critical, because there was not overwhelming evidence in this case. There was nobody that could ID the shooter. There were photo lineups that were provided to the witnesses, but those witnesses only ID'd Dundell Cash as someone they saw earlier in the club.
When did your witness die?
Our witness died on October 2010, Your Honor.
And so how much delay was there as of that point?
Your Honor, there had been, if we look at our timeline from the true bill, from the no bill, there had been 6 months after the state, and this is critical. A critical fact also is that the state ADA and the defense trial counsel testified at the motion for new trial hearing that he is 100% sure, unequivocal, that the ADA called him when the no bill came down and told him that the grand jury no billed the indictment, the sole eyewitness is dead. At that point, the defense trial counsel closed his case. There's nothing left to do. There's no point in wasting the defendant's money and continuing to, gather.
Was there evidence that the ADA was lying?
The ADA said that he could not remember what he said.
Yeah. And who gets to decide that issue?
The trial court can find the credibility of witnesses at a motion for new trial hearing. That's true. But a trial counsel for the defense specifically unequivocally said he's 100% sure.
Okay, and the judge could say, I don't care what you say, I don't buy it, right? And then what do we do?
You review for abuse of discretion, that's correct. But Your Honor, when we look at the other factors, the prejudice prong not only dealt with Calvin Jones, the witness that had died during that delay, but it also dealt with gentlemen Ben Freeberg and Stephen Bell. And they were unavailable for trial because nobody could find them. The defense did not continue to look for their witnesses when the state told them that the sole eyewitness had died and the grand jury no-billed the case. And their information that was provided the night of the shooting said that they were actually one of the only witnesses that had interaction with the alleged shooter at a gas station next door. They were within feet of the alleged shooter because the alleged shooter came up to Stephen Bell and said, was on the phone and said, "Are you calling a taxi?"
Let's come back to the 71-month delay between the no bill and the true bill, because that is really the lion's share of the time that we're talking about here. And in trying to figure out exactly how that ought to factor in here, one of the things that isn't clear to me from the record or the briefing is, were there any restrictions on your client's liberty during those 71 months? Was there a bond, conditions, or anything like that that functioned as a restraint on liberty, or was your client just completely free?
Your Honor, our client was free and so to speak, because the no bill came down. He wasn't
And
on
so
bond.
there was no bond, there was no, okay.
That's correct. But the prejudice comes from the fact that because the state told the trial counsel that the sole witness was dead, it was a domino effect. So we never went out to get Calvin Jones' a statement because the case was essentially closed. We never followed up with witnesses because we were told we relied on the state's misrepresentations that the case was closed, when in actuality the state was running an annual criminal history search for the alleged sole eyewitness. And if I can go back to that length of delay, I'd also like to point out that I'm not sure if there's a pattern, but less than 2 weeks ago in Davis v. State, this county came up before your court and argued that even though a rape allegation from 1996 was beyond the statute of limitations and the defendant was held in jail for over 937 days, they still had not indicted the case. And what I'm trying to show to the court is that the state cannot simply hide behind this cloak of negligence and always have it be benign against them when something so egregious as this case caused prejudice to our client's trial.
But the judge didn't find any prejudice, right?
The judge found that the prejudice did not weigh in favor of appellant.
Right. So, I mean, the judge... It's a little hard to figure out what to do with prejudice here, because this is another area where, frankly, our case law in the 11th Circuit diverges a little bit. Because the 11th Circuit has said, you know, without a showing of actual prejudice, you can't win a speedy trial motion. We have said the opposite, that if the other factors weigh heavily enough in favor of the defendant, the presumed prejudice that gets you into the Barker analysis to begin with may be sufficient.
That's correct, Your Honor.
But here, you know, the judge didn't weigh the first three factors heavily against the state. So don't you need to show some prejudice?
Yes, Your Honor, we do have to show prejudice if this court does not find, or if the trial court didn't find that the other three factors didn't weigh heavily.
And the trial court didn't find that the other three factors
That's
weighed
correct. We would argue that once this court remands it, we'd ask that they find that this court asked the trial court to find.
So why do we remand?
For the lower court for the lower court to correctly weigh those factors. So for the length of delay, for the trial court to consider the pre-indictment delay when determining how heavily to weigh against the state.
What error did the trial court commit in not weighing that heavily against the state?
I mean, we understand you disagree with it, right? We get that, but I think what we're trying to get to is what is the legal basis on which we could actually reverse?
The legal basis is some of the points in the trial court's order. We'll say, for instance, the trial court's order in determining the length of delay. The trial court specifically considered the defendant's alleged flee of prosecution. This was unsupported by the record, so the abuse of discretion standard doesn't apply here. So in that particular instance, there was no evidence that the state put on that the defendant knew of the arrest warrant. There was no evidence that his family knew of the arrest warrant or even alerted him of the arrest warrant. The only thing that state presented was that he was arrested in South Carolina, and that's not enough to show that the defendant was allegedly fleeing from prosecution. So there's one instance where the trial court erred in finding something that was unsupported by the record. So that's just one particular instance in which I'm asking this court to remand so the trial court can properly determine the Barker factors and weigh them accordingly.
So are you arguing that there are enough instances where the trial court was clearly erroneous in its factual findings that cumulatively that meant that they misweighed the factors as a matter of law?
Yes, Your Honor.
What else? Because, I mean, I'm not sure you can't draw that inference of flight. But where, on the prejudice side, you talked about your other two witnesses, but the trial court specifically made a finding that the defendant didn't show that those witnesses became unavailable during the delay. I mean, your argument is kind of, well, we were misinformed about what was happening with the case, so we stopped investigating. That's a different issue than you can't show that even if you hadn't stopped investigating, you would have found the witnesses.
That's correct, Your Honor, but it stems back to the fact that we relied on the state's
So
misrepresentation.
let's say, but you still have to show prejudice from that. Let's assume the state erroneously told you that the case was done. If the state hadn't erroneously shown it and you still couldn't find these two witnesses, there wouldn't be any prejudice, right?
We can speculate to that, Your Honor.
Well, no, we don't have to. It's your burden to show error, and so you would have to show that you could have found these witnesses had you not been misinformed.
And the defense counsel at the motion for new trial hearing said that he did have his investigator search for him. He did run social media searches.
Did he find them?
He could not find them,
Okay, well, so.
but he stopped looking because of the state's misrepresentation.
But you'd have to show that he stopped looking and they were right down the street. So if he had looked, he would have found them. If in fact they were dead, or they had moved to Guatemala or Sweden or somewhere else in the world and he couldn't find them, there wouldn't be any prejudice at all, right?
That's correct, Your Honor.
And we don't know because no facts were established to show what happened to those witnesses during the relevant period.
Other than trial counsel stating what he did to try and find them prior. That's correct, Your Honor. But
Can we come back to the pre-indictment delay, or it's a little silly to call it pre-indictment, pre-true bill delay, I guess. The 11th Circuit case law and the Second Circuit case law saying, although you don't consider it to go into Barker, once you're in Barker, it's appropriate to consider in weighing the post-indictment delay. Are you aware of any cases saying that it is reversible error to elect not to?
I did not find that case law, Your Honor, because this is such a interesting circumstantial case where there's one presentment of an indictment, which is no bill, and then delay, and then another indictment. It was hard to find case law that, and with pre-indictment delay in particular, other than the 11th Circuit and Second Circuit ruling that way, I could not find a case law which said that. But as the Supreme Court has said, these are flexible factors. And they, like I said, they have no talismanic qualities. They should be considered with other circumstances that are relevant.
The problem with that is, to the extent they're flexible, the Supreme Court and our court have said over and over that flexibility is given to the trial court to determine flexibly how to apply them. So if they're really flexible, then we're going to say no abuse of discretion. It's only where they're inflexible that we can say the trial court clearly made an error.
That's correct, but I'd ask this court to also look at the other areas of the order in which the court was clearly erroneous, or they've made findings that was unsupported by the record. And if I may, if there's no other questions, I'd like to reserve the rest of my time.
Thank you, Mr. Rice.
Thank you.
Ben Gephardt, Chattahoochee Judicial Circuit for the appellee. May it please the court. In January of 2017, a Muskogee County jury convicted the appellant of malice murder and felony murder for the shooting and killing of Ewan Dougal. The appellee has not raised the issue of sufficiency of the evidence or general grounds below. His guilt is not at issue. The only issue is whether the appellant received a speedy trial as guaranteed by the Sixth Amendment of the Constitution. And although this case is unusually complex factually and procedurally, the correct resolution of this case is very simple, bearing in mind two principles. One, the Sixth Amendment to the U.S. Constitution, its speedy trial guarantee only applies to accused persons. And second, issues of credibility and the weight of evidence belong to the trial court as finder of fact. Regarding fact, the appellant's factual account of this case has a very tenuous relationship with reality, particularly his allegation that an innocent man may be languishing in prison.
Well, let's set that aside for a minute, because the speedy trial issue doesn't really involve innocence or guilt. Talk to me about the role of the pre-true bill delay, those 71 months. To what extent ought those to have been considered in weighing the post-true bill delay against the state?
Based on this court's precedent, none at all.
Do we have any cases saying that explicitly?
Not explicitly, but this court has never followed Ingram, and which I've laid out in the brief.
Have we said we're not following Ingram?
Yes, although not that particular part of Ingram. This court has declined to follow its balancing test as being an inflexible variant of.
Well, and I mean, the part of Ingram that we haven't followed is the part that says you're always required to show actual prejudice.
Yes, that's correct.
Right. So we actually said it's easier to get a speedy trial motion granted than it is under Ingram.
For that part of the Ingram
Yes.
analysis, for the consideration of pre-indictment, although as Your Honor noted, it's kind of using these terms is very complicated.
We'll
in
use
this
it in
case.
shorthand here.
But let's say the interim delay.
Right.
This court has never followed Ingram in considering pre-indictment delay.
So far as I can tell, we haven't weighed in on the issue one way or the other.
And I would agree with that.
So this is a case that requires us to weigh in on that, maybe, for the first time. How ought we to think about that? If we're going to say that we think the 11th Circuit and the Second Circuit are wrong, we need to have a thoughtful reason for doing that.
The other, well, I've laid out some of it in my brief, but as applies to this particular case, I think one major difference, and this is regardless of whether you decide to apply Ingram or not, this case involves the search not of a defendant after the completion of a criminal investigation. This involves an ongoing investigation and the search for a critical witness, which is awarded.
What was the search that was ongoing? The annual Lexus search?
Yes, and
I'm not sure we want to call that an ongoing investigation.
Well, I would take issue with the appellant's characterization of that search.
Okay, what more was going on?
Well, it was not just a search of his criminal record. It was a searching of criminal databases and sending out letters and replying to those letters. There is more than one Dennis Archer out there. And I would note that search was eventually successful, and a letter did reach Dennis Archer, and he reached out to our investigator, and that's how this case came to trial.
What changed between the things you were doing, or the office was doing at that point in time, and then the point in time where he actually responded?
Do you mean from the time of the no bill, or?
Well, I mean, didn't you just say that every year they were running the searches, they're sending out letters?
Yes.
No one's responding. At some point in time, he responds.
I think what probably, I mean, and the record isn't terribly clear on this point, but I think what happened is the witness, who at the time of the murder was homeless, found employment, got a stable address, and started receiving bills, which made more things pop up in Lexus. And now that he's in the habit of answering his mail, that's probably what brought it to his attention. Prior to that, we had gotten addresses from, for example, he had received some mail apparently in general delivery in Tampa. He had been at halfway houses, various homeless shelters, and we had sent letters there. But I think what changed and why he was eventually found was he did gain employment at Walmart and got a stable address, and that's how he ended up responding to our letters.
Coming back to the issue of how we count that pre-indictment delay, if we were to conclude that the way the 11th Circuit and the Second Circuit treat the issue is correct, would we need to vacate and send it back for the trial court to exercise its discretion again as to how to weigh that delay? Or can we infer that the trial court sort of already did what we hadn't told the trial court that it needed to do?
Well, the problem there is that's sort of retroactively applying Ingram, which has never been adopted by this court.
Well, it's not retroactive. It's on direct appeal.
Well, at any rate, the other problem with it is that do we count the first delay twice then? Because, or do we count only the interim period? Ingram really gives us no guidance on that issue. It's never been applied to a case like this where you have a bifurcated period of prosecution. The one case where that has happened post-Ingram in the 11th Circuit, they did not apply Ingram and passed over it in silence. And incidentally, finding that a witness who had died during that interim period should not be counted as prejudicing the defense because his Sixth Amendment rights were no longer in effect.
Counsel, it seems to me, and I'd like to get your response to this, but in defense of Ingram, it seems to me that the speedy trial right essentially means that once proceedings commence, The state can't drag things out and go too slowly. The state needs to move with some reasonable promptness in completing the prosecution for a variety of reasons. One of those being that time is usually not the friend of truth-seeking. That as more time goes by, memories fade, witnesses become unavailable, and so usually seeking the truth is impaired by the passage of time, usually. But that does not answer the question of how slow is too slow. And that may vary from case to case. And it's my understanding of Ingram that where the pre-indictment delay comes in is when there is an arrest made on the day the crime is committed, it may be okay to go a little slower because by the time you get to trial, even if it's 2 years later, the witnesses are still only testifying about things that occurred 2 years before. On the other hand, when a case was cold for, let's say, 20 years, and then the state finally gets an indictment and makes an arrest, every day that goes by, you've already got 20 years of delay to start with. Those memories are already faded for 20 years. So you add 2 years, now you're up to 22 years. So maybe there is a reason for the state to proceed more urgently when a case has been cold for a long time. What's your response to that?
Well, the first response is that that general concern about the length of time and the accuracy of memories is mainly addressed by the statute of limitations. That's the primary vehicle for addressing those concerns, and specifically, this state has no statute of limitations on murder.
So then maybe it doesn't address that concern in the murder context very well. Wouldn't the Barker factor that would actually address that concern better than the length of delay standing alone is the prejudice prong, right?
I think so. And in this case, the trial court specifically found no prejudice, and I think a review of the record would support that finding. The only evidence from one of their alleged missing witnesses, Calvin Jones, who never made a statement to anyone regarding what he witnessed that night, the only possible statement, and well, let me back up a little bit. The only evidence we have of what he observed is the defendant's own self-serving affidavit speculating as to what he would have observed. There's no statement of Jones to review. So that I think that demonstrates that he was not prejudiced in that regard. Similarly with Stephen Bell and Ben Freiberg, their statements were read into the record, leaving any prejudice. So I think the prejudice concerns in this case have been adequately addressed and at the trial level, and that's reflected in the trial court's order.
I mean, although part of the reason that we credit, my reading of the U.S. Supreme Court is they have credited presumptive prejudice, even when there's no showing of actual prejudice, is it's very hard to measure the impact that the fading of memory has. It's one thing to be able to point out a witness who has disappeared or a witness who has died, who was in fact alive and available to testify at some earlier point in time and they no longer are. But it's very difficult to measure what is the extent of prejudice and who is prejudiced by it, whether it's the state or the defendant, by the fading of memories. And so that's the reason that we have a presumption of prejudice when you get to a point of delay that carries some weight, at least, in the prejudice analysis, right?
Yes, but the other problem with that analysis is that there is additional Supreme Court precedent out there, specifically Marion, Loudhawk, and McDonald, that says the Sixth Amendment does not apply once the state in good faith dismisses an indictment, and that's what we have in this case. So that delay does not really count in the Sixth Amendment analysis at all.
Well, I think it's not obvious that the conclusion follows from the premise, because the Sixth Amendment doesn't apply once the state in good faith is dismissed, but then it reapplies once you get your true bill.
Yes.
The statement that it doesn't apply during that interim doesn't mean that interim is irrelevant to the Sixth Amendment analysis once you've gotten your true bill again, right?
Well, I would point out
the Supreme Court hasn't rejected what the 11th Circuit and the Second Circuit do, right?
I don't think it has had occasion to yet, but yes, it has not rejected. Ingram is still good law in the 11th Circuit. But I would point out that where it would conflict with McDonald and its progeny, that the Supreme Court precedent really must prevail. And this court has so held recently in the Hurd case with a very similar sort of procedural and factual problem with a lengthy period of delay between indictments, and has passed over the idea without comment that there could be presumptive prejudice from that length of delay.
So when we talk about presumptive prejudice, which by definition is not actual prejudice that has been found by a trial court, how much weight is it appropriate to afford presumptive prejudice with no evidence of actual prejudice? I mean, can a judge say the presumptive prejudice arises simply from the number of months that it's been, and I'm going to, just do a numerical weight? So if it's been 13 months, that weighs 0.13, and if it's been 71 months, that weighs 0.71. How does that work?
Well, I can't point to a specific number or formula, and I don't think Georgia has ever established one. But there has been, the general rule is that 5 years is enough to establish presumptive prejudice. But
I think the general rule is in Georgia, 1 year is enough to establish presumptive prejudice.
Under the fourth prong, then, at any rate, I don't think there has been a numerical formula, but there has been rulings to suggest that, not just to suggest, but to hold that presumptive prejudice alone is not enough to succeed on a speedy trial motion.
In this court?
I think we've expressly said that that's not the law in our court.
Yeah,
Is this an area where we would give flexibility to the trial court? I mean, presumptive prejudice might matter a lot more if the case were based on, a event in a senior citizen's home with a lot of people with more quickly than average fading memories, and that was all you had is 5 eyewitnesses or 1 eyewitness, as opposed to a case with physical evidence where, fading memories is a lot less important.
I think so, and that's one of the reasons why this analysis is entrusted to the trial court's discretion. In this case, we don't have a situation like that. We have a situation full of young witnesses, some of them in the military, and the witnesses of the bar staff who identified the defendant by name, not by ID and not by clothing, but by name, as standing next to the victim seconds before the shooting started. So I think any impact from presumptive prejudice is negligible in this case. There's no reason why witnesses' memories would have faded to the extent that they would not be able to produce a just result. And particularly, I would point to this court to the trial court's finding of fact, which are reviewed for not for abuse of discretion, but for clear error. Regarding the finding of flight, the defendant was observed by several witnesses running from the scene of the murder. There was evidence of media reports raising the hue and cry, including testimony from the defendant's own trial counsel that he had read news reports from the time of the murder, and a search of his home and known addresses, and then finding the defendant in a neighboring state 2 years later. And I would also point out that given the date of the trial court's calculation of the delay, the flight of the defendant did not enter into that calculation because all of it occurred pre-arrest. The trial court mentioned it as one of the circumstances of the case relevant to the threshold question, and really all circumstances of the case are relevant to the threshold question, but did not include that time in its length of delay calculation or in the reason of delay calculation. The court did mention it a second time in discussing the materiality of the evidence of the missing witnesses as part of the evidence of the case. And I've cited cases in my brief that say that sort of evidence is sufficient for a jury to infer fleeing and infer consciousness of guilt. So I don't think it has really any bearing on the speedy trial analysis other than for the threshold question. And even if that was error, it did not harm the defendant because he met that threshold anyway. And the court then proceeded on to the next phase of the Barker analysis. Further, the trial court found that the search of the defendant, the search for the missing witness, was diligent, and that's supported by not just by the search post no bill, but also by the search After the preliminary hearing, when it was rumored that he was dead, they contacted numerous state offices, probation offices, coroner's offices throughout Georgia and in neighboring states, searched commercial databases, and ran criminal histories. And this, compared to the search in Heard, I think it's pretty comparable. In Heard, the trial court's finding of diligence was left undisturbed when the search was conducted by the investigator only in her spare time. And I think similarly here, an annual review of that search is sufficient to sustain the trial court's finding. Further, the trial court had twice heard the trial counsel make the argument first at his motion to dismiss hearing that he was lied to, didn't buy it then. Heard him on the stand testify that he had been lied to by the state, and heard testimony from the ADA that no, he did not lie, and didn't buy it then. That is, he didn't buy the story of the allegation. And regarding the theory that, well, the ADA...
Can I just ask a couple of quick record questions on a different point? First point, you were talking about the continued investigation during the 71 months and the letters that were going out after the no bill. Is the fact of those letters in the record anywhere?
Yes, it is. It's part of the exhibits in the motion to dismiss hearing.
Okay.
The state's exhibits 1 and 2.
Okay. And then the South Carolina arrest, which your friend across the way mentioned during argument, is the fact of that arrest inconsistent with his claim that he was complying with probation in Muskogee County?
It's inconsistent with that claim, but it's also, that claim is itself untrue. He was wanted by probation starting in 2005, and probation had no contact with him after November of 2005.
Is that in the record?
It's not in the record. The state was not aware that that issue would be raised. It was not raised in the amended motion for new trial and had not previously arisen, so the state was not on notice to investigate it. After the motion for new trial, I did reach out to the probation office, and they informed me that no, he was not reporting to probation. He last reported, and the records aren't clear on this point because
but none
it's been
of
so
that's
long.
in the record in this case.
Right.
Okay.
But I would point out that at the only evidence that, and I wouldn't even really characterize it as evidence, the only evidence of probation is really argument. The trial counsel was asked whether he was on probation, and he said that was my understanding, not that he knew he was on probation. And then when asked whether there were any probation violations, he did not say, I investigated and found there were none. He said, I was not aware of any. So I don't think there really is any evidence of the record of his compliance with probation or any evidence of his whereabouts from the time of the murder to his arrest. My time is almost up. If there are no further questions, I would just ask this court to respectfully affirm this appellant's convictions and sentences. Although it has taken let me just say although it has taken a long time to bring him to justice, his constitutional rights have not been violated. Thank you.
Thank you, Mr. Gephardt. Mr. Rafis.
Your Honors, I'd just like to point out a few things while I have a little bit of remaining time. The first is that, as my colleague just mentioned, they said that the state wasn't on notice that the defendant was on probation, and that just goes directly back to their lack of investigative skills. That they didn't know that a defendant that they had arrest warrant outs was on probation in the same county that the arrest warrants were for. And as far as the investigation, or lack thereof, goes for Dennis Archer, all the letters that were mentioned that were brought up as an exhibit in the motion to dismiss hearing, those were all sent pre the no bill in January 2009. After that, and the motion for new trial transcript, I believe it's page 75 that this court will see, the only thing that they did was run a single search once a year. And the state has a duty to bring the defendant and its witnesses to trial.
Are you saying they didn't find him through a letter sent?
There's no, Your Honor, if you go back to page, I believe it's 75 in the motion for new trial here, transcript, I don't believe there's anything that mentioned how Dennis Archer was found as far as the letters go, but only that they would testify, the witness testified that they only did a single search once a year.
What's the best evidence of what Mr. Jones would have testified to that's in the record?
Chief Justice, Mr. Jones would have testified to, because he picked up Dundell Cash on the night of the shooting.
What's the best evidence of?
Would have testified to the clothing that he was wearing.
It's a different question. You're telling me what the testimony would be. What's the best evidence of what that testimony would be?
The only thing we have, Mr. Chief Justice, is the affidavit from Dundale Cash, because during the delay, he died. We can't go back and revive him as the state did for Dundale Cash to get that testimony. And the state was negligent in every aspect of this case. And for the state to hide behind that egregious negligence lasting over 10 years is wrong. And we ask for a remand so the trial court can properly weigh the Barker factors. Thank you.
Thank you, sir. Ms. Barnes, you call our last case, please.